One of the reasons I wanted to talk about the WARN Act is because we just got finished launching a furlough guide for employers. And one of the things that we talked about was the difference between a furlough and a layoff. A furlough is a temporary reduction where those people are likely returning. However, if you make the decision to move from furlough to go ahead and making notice of that reduction, you might trigger a WARN notice. Now, that happens if you have 100 employees and or these employees collectively work at least 4,000 hours in a week period. This could include part-time employees or full-time employees, and a part-time employee is someone who works 20 hours or less. So when your employer decides to do a mass layoff, they need to notify employees and they have to give them 60 days notice. Now, the employer needs to notify them with a letter or an email or some sort of notification. Sometimes that happens over a Zoom call, which we're seeing a lot of those happening right now. Now, there are some instances when employers don't have to give that 60 days notice, and I'll talk about those in just a second. Now, there are some examples of when you don't have to give a 60-day notice under the WARN Act, and that is really in three situations. The first one is a natural disaster. Now, believe it or not, coronavirus is not considered a natural disaster. A pandemic is not considered a natural disaster, so it wouldn't fall under one of these three situations. The second one are unforeseeable business circumstances, which, given what has happened with the shelter in place and so many businesses forcing to be closed, you might not have to provide a WARN notice under unforeseeable business circumstances. The third reason that you might not have to provide that 60-day notice under the WARN Act is a faltering company. If you were looking for funding and you weren't able to secure it, your business closed down, you don't have to provide the 60 days notice to the employees as outlined in the WARN Act. These are just some examples, and I wanted to provide some context about what the WARN Act is, because right now there are a lot of employees who are being impacted. As an HR leader, you're also thinking about these too. And as you prepare for your HR certification, whether it's HRCI or SHRM, it's likely that some information or questions about the WARN Act will be asked. But more importantly, it's important for you to have access to this information so that you can advise your employer as an HR professional on what they should or should not do. As always, I suggest working and consulting with an attorney before you make a decision like this, but this is an important topic for you to be aware of in preparation for your HR certification exam. That is the WARN Act. It is the Workers Adjustment and Retraining Notification Act of 1998.